Hello everybody, welcome to jurycentral.com online classes for law exams. So today I will be discussing with you the monthly roundup of Supreme Court cases of the month August 2021 for your upcoming UPSC Public Prosecutor exam or judiciary exams or LLM exams. So these case laws are very much important for your law entrance examinations. So I will be discussing with you only the important case laws which are important for the examination point of view. So let us start. The first case is Neeraj Garg versus Sarita Rani. So in this case, the court has held that judges should exercise restraint and avoid unnecessary remarks against conduct of the counsel. In this case, Supreme Court ordered expunging adverse remarks taken advocate with 17 years of standing at the bar. So let us see the facts first. The appellant was a practicing advocate before the Uttaranchal High Court with around 17 years of standing at the bar. The focal point of the matter arose from 4 cases before the High Court in which the appellant represented one of the contesting parties. In those 4 cases, the presiding judge of the High Court made certain adverse observations remarks against the appellant. So I hope you have understood. In this case, the counsel who had a 17 years of practice before Uttaranchal High Court has been court has made some adverse remarks against his professional conduct, and against that order the appellant actually challenged in the Supreme Court to expunge those adverse remarks, as those remarks are having very bad impact on his professional career. In this case, the court observed, while it is of fundamental importance in the realm of administration of justice to allow the judges to discharge their functions freely and fearlessly and without interference by anyone, it is equally important for the judges to be exercising restraint and avoid unnecessary remarks on the conduct of the counsel which may have no bearing on the adjudication of the dispute before the court. So that's what the Supreme Court observed, that the judges shall refrain from making such remarks which have actually no relation with the adjudication of the dispute before the court. Then the next case is North Delhi Municipal Corporation versus Dr. Ram Naresh Sharma. In this case, the division bench of N. Nageshwara Rao and Rishikesh Roy justices held that doctors both under Ayush and CHS render service to patients, and on this core aspect there is nothing to distinguish them. No rational justification is seen for having different dates for bestowing the benefit of extended age of superannuation to these two categories of doctors. So in this case, the Supreme Court has made it clear that the doctors who are practicing under Ayush or practicing for allopathy, there shall be no distinction to be made in terms of their age in relation to superannuation, that means retirement. So let us see the background first. Instant appeals were filed directing against the judgment and order passed by the Delhi High Court, whereby the court upheld the decision of the Central Administrative Tribunal and dismissed the petitions filed by the North Delhi Municipal Corporation. What did CAT declare? So let us understand. CAT held that applicants who were Ayurvedic doctors covered under Ayush were also entitled to the benefit of enhanced superannuation age of 65 years, raised from 60 years, just like the allopathic doctors. So that's what the High Court has actually upheld the decision of the Central Administrative Tribunal, and the NDMC has challenged this before the Supreme Court, in which the age of retirement for Ayush doctors has been increased to 65 years from 60 years. Then the third case is State of Haryana versus Rajkumar. A division bench of Hemant Gupta and A.S. Bopanna justices disposed of a criminal appeal holding inter alia that if a prisoner has undergone more than 14 years of actual imprisonment, the state government as an appropriate government is competent to pass an order of premature release, but in case of the prisoner who has not undergone 14 years or more of actual imprisonment, The governor has power to grant pardon, reprieve, respite and remission of punishment or to suspend, remit or commute the sentence of any person. So in this case, it has been held that suppose if the prisoner is undergoing sentence of more than 14 years, so in those cases, the power to suspend, remit or commute actually lies with the appropriate government. But if the convict has undergone imprisonment of less than 14 years, then the governor has the power of remission, pardon, reprieve, or respite, etc. under Article 161. Then the next case is Banka Sneha Sheela versus State of Telangana. In this case, it has been held no preventive detention on ground of a possible apprehension of breach of law and order. Supreme Court explains true import of public order. In a case where the detainee was accused of committing a series of criminal offences from October 2017 to December 2019, such as cheating in the guise of providing good profit to people by investing their money in stock market and collecting huge amounts to the tune of more than 50 lakhs, a bench of R.F. Nariman and Rishikesh Roy justices quashed the detention and held that in such a case. So in this case, actually the Supreme Court has held that on the name of breach of law and order, preventive detention cannot be a possible ground. And also it explained what are the cases which actually falls under public order. In this case, the accused was actually he was actually charged of committing series of criminal offences like cheating people. So in this case, the Supreme Court has held that his preventive detention is not valid on the grounds of possible apprehension of breach of law and order. So in this case, the Supreme Court has held that at the highest, a possible apprehension of breach of law and order can be said to be made out if it is apprehended that the detainee, if set free, will continue to cheat gullible persons. This may be a good ground to appeal against the bail orders granted and or to cancel bail, but certainly cannot provide the springboard to move under a preventive detention statute. So like if that person is accused of cheating people, on that ground, his bail application can be rejected, but that won't be a valid ground of preventive detention. Then the next case is Brajesh Singh versus Sunil Arora. A division bench comprising of R.M. Nariman and B.R. Gavai justices found several political parties guilty of contempt of court for non-compliance of directions given by the Supreme Court in Ram Babu Singh Thakur versus Sunil Arora, decided in the year 2020 in connection with disclosure of information of candidates with criminal antecedents. So this case law is very important, and in this case, the Supreme Court has directed to disclose the information of candidates who has previous criminal antecedents before going for the elections, and because those directions were not followed. So the Supreme Court has actually found several political parties of the guilty of contempt of court for non-compliance of those directions given in Ram Babu Singh Thakur versus Sunil Arora. Penalties have been imposed on the political parties found guilty. The court also issued further directions in order to make the right of information of a voter more effective and meaningful. The instant contempt petition arose out of elections held to the Bihar Legislative Assembly in October and November 2020. The sixth case is In re suo motu writ petition, very important case law. While addressing the issue pertaining to the unfortunate demise of the judicial officer Uttam Anand, the three-judge bench comprising of N.V. Ramana's Chief Justice, Vinit Saran and Surya Kant justices emphasized the institutional need to create a safe and secure environment for judicial officers and legal fraternity. So this case, this actually suo motu case, and it has been taken up by the Supreme Court on the demise or say the deliberate killing of a judicial officer of Jharkhand, Mr. Uttam Anand. And in this case, a suo motu case was registered by the Supreme Court for addressing the issue of safeguarding courts and protecting judges. Noticeably, the issue came into light after an unfortunate incident that took place on 30th of July 2021 when an additional sessions judge posted at Dhanbad was hit by an auto rickshaw and he died as a result of the injuries caused to him. Finding that there was an urgent need for wider consideration and consequential detailed explanation by all concerned, a notice was issued to all other states and union territories in this regard. Additionally, by its recent order, the Supreme Court had directed the Central Bureau of Investigation to file a report before the High Court of Jharkhand every week, and a further request was made to the Chief Justice of the said High Court to monitor the investigation with regard to the sad demise of Judicial Officer Shri Uttamanand. So this case law is very important from the perspective of the protection of judges and the judiciary. Then question number 7, Parubhai versus State of Maharashtra. This is a very important case law in terms of Indian Evidence Act, as it involves the element of circumstantial evidence. A division bench comprising of Hemant Gupta and A.S. Bopanna justices reversed the conviction of the accused appellant, who was convicted for the murder of her husband, first wife and their children. The Supreme Court held that the chain of circumstantial evidence was not complete and gave her a benefit of doubt. And now we'll understand the facts. The appellant was married to one Gulab, who was already married to Manda Bhai, who is a deceased, and who is also the first wife of Gulab. Gulab and Manda Bhai had 2 children, one son and a daughter. The appellant and her husband, the deceased, the children, appellant's parents-in-law and their servant all lived together in one house. The prosecution case was that on the intervening night of 2nd and 3rd August 2006 at about 2:30 to 3 a.m. an incident of fire occurred at their house and it was engulfed into flames. The appellant, who was also in the house, came out unscathed. Manda Bhai and her daughter rushed out of the house with burn injuries, while her son burned to death inside the house. Unfortunately, both Manda Bhai and her daughter died on the next day due to burn injuries. So, the first wife of the appellant's husband and her daughters were actually died due to burn injuries, but the appellant itself, who was also staying in the same house, came out of the house safely. It was noted that there are equal circumstances which raise a doubt whether the appellant could be held guilty only because she was not injured in the incident. So that was the main issue. And this is the reason why she was actually convicted, because there was some doubt that how come when the other family members who were inside the house were actually burned to death, how come she came out safely from the house? The court said that the natural human conduct is that when there is any incident or accident, the immediate reaction is to get away from the scene and to save oneself. The court was of the view that if in the middle of the night, for whatever reason, there was fire and if the appellant had woken up and noticed it a little earlier, the natural conduct was to run out of the house instead of going into the house which was burning to check on other inmates. It was observed. So here the Supreme Court actually observed that it's a natural human conduct. Like when a person is in danger, he will try to save himself instead of having thought about the safety of others. It takes a lot of courage or be overdriven with compassion to get back into the house to save somebody else, and not doing so may be considered morally wrong for not coming to aid of fellow human being in distress, but cannot be a circumstance to hold a person guilty of a crime which is as serious as murder, unless the other circumstances in the chain point to the accused so as to lead to an irresistible conclusion of being guilty. That's what the Supreme Court observed. The next case is Siddharth versus State of UP. A division bench of Sanjay Kishan Kaul and Rishikesh Roy justices has held that if the investigating officer doesn't believe that the accused will abscond or disobey summons, he or she is not required to be produced in custody, while remarking that if arrest is made routine, it can cause incalculable harm to the reputation and self-esteem of a person, the Supreme Court observed. Again, a very important case. Now, in this case, the Supreme Court has said that it is not necessary that the accused has to get arrested by the investigation officer in all offences. Suppose if there is actually no doubt that the accused will abscond or he will disobey summons, then in those cases it is not necessary that he shall be arrested. And also, if arrest is made a routine exercise, then it will cause incalculable harm to the reputation and self-esteem of a person. So in its words, the word custody appearing in section 170 CRPC doesn't contemplate either police or judicial custody, but it merely connotes the presentation of the accused by the investigating officer before the court while filing the charge sheet. So according to section 170, like whenever a police is forwarding the police report to the magistrate court, then it has to be submitted in the presence of the accused. Then question number 9, Lala versus State of Maharashtra, again very interesting and very important case law. A division bench of Sanjay Kishan Kaul and Rishikesh Roy justices took the liberty of disagreeing with one of the most famous lines penned down by the Bard of Avon, who is also known as William Shakespeare, to suggest that much indeed is in a name. William Shakespeare has once said that what is in a name, but in this case the justices of Supreme Court actually disagreed with that term and said that much indeed is in a name. That means name actually makes a much difference. The Supreme Court reiterated the necessity of referring to guidelines regarding inadequacies and deficiencies in criminal trials. The court also took note of the draft rules of criminal practice 2021, which dictate the manner in which depositions must be translated, the court observed. So what the court observed, the practice of translating any relevant document must not differ so significantly across forums and submissions by party to cast severe aspersions on evidence which may otherwise be not warranted. Idiosyncrasies of colloquial terms used for naming an accused could well be the difference between conviction and acquittal of an accused. So idiosyncrasies means actually what a person thinks or his conduct is actually peculiar to what to what is actually in general. So let us see the facts of the case. The court was deciding an appeal against the judgment of the Bombay High Court whereby the appellant's conviction in a murder case was upheld. So this is actually the case. The crime was committed in January 2009 when a group of 10-12 persons murdered one Balu by attacking him with dangerous weapons. The FIR was filed by one Arun who tried to save Balu but was himself injured in the assault. Notably, the appellant was not named in the FIR but was described by his build and appearance. He faced trial with other co-accused and was convicted for several offences under the penal code. The High Court upheld his conviction, aggrieved the appellant approached the Supreme Court on the following grounds. I hope you understood. So this is actually relating to a murder case in which the FIR was filed by one Arun who actually tried to save Balu, who was attacked by 10 to 12 persons. And here the appellant was not named in the FIR but he was actually described by his build and appearance, and this is a reason why he challenged the same before the High Court, which upheld his conviction, and later he went on to Supreme Court. The main argument of the appellant was that he was not amongst the accused named in the FIR, and as the prosecution did not arrange for test identification parade, his identity as an accused could not have been clearly established. Second, considering the record, the court found that while the FIR did not disclose name of the appellant as one of the accused, however, the eyewitnesses identified as the appellant in supplementary statements. They named the appellant and ascribed specific role in the attack. So here one thing is very important in this case. No test identification parade was held for the identity of the accused, but he was identified by the witnesses in the court during recording of the statements. Notably, the eyewitnesses referred the appellant Lala or Leila at several places. On this, a court opined that the colloquial variation was so far removed as to rendered the identification unreliable, particularly when no other person by such name was amongst the accused group. The court, however, made a very interesting remark. So even in the in the statements recording by the witnesses, in so many places his name was actually misspelled as Leila. So the court in those circumstances, court has held that just because of the colloquial variation, his conviction cannot be set aside, because among the group of the accused who killed the victim, none of the person is by name of Lala or Leila. Then this 10th case is Pichhda Varg Kalyan Mahasabha Haryana versus State of Haryana. A division bench of L. Nageshwara Rao and Aniruddha Bose justices quashed the notification dated 17th of August 2016 issued by State Government of Haryana, which specified economic criterion as the sole basis of identification of creamy layer socially advanced sections. Among backward classes, for excluding them from the purview of benefit of reservation in state services and admission to educational institutions, the Supreme Court reiterated that the basis of exclusion of creamy layer cannot be merely economic. So in this case, the notification of Haryana government of the year 2016 has been quashed, in which the government has prescribed that the creamy layer criteria has to be identified based on the economic criteria of the candidates. And in this case, the Supreme Court has said that the exclusion of creamy layer cannot be merely economy but also on the other factors. Then the next case is Madhav versus State of MP. A division bench of Indira Banerjee and V. Rama Subramaniam justices reversed concurrent judgments of the trial court and the Madhya Pradesh High Court, whereby 3 persons were convicted in a murder case and sentenced to life imprisonment. The Supreme Court found that the police investigation in the case was done under political pressure for extraneous consideration designed to turn the informant and her family members as accused and allow the real culprits named in the FIR to escape. So this is a very interesting case law. So I haven't discussed the entire facts. So I would suggest you to read it by yourself. I have already shared the citation with you. So in this case, the conviction of the 3 persons who were convicted for a murder case was set aside on the grounds that their conviction was actually politically influenced, and they were the complainant and not the accused, as mentioned, because it is actually, this conviction is done actually to allow the real culprits named in the FIR to escape. So this is the session for today, and I hope you all have liked it. Do not forget to give a like, share and subscribe to the channel. So till we meet the next time, thank you and have a nice day.